Welcome back to our Bridge City News special report on Indigenous land rights. In our earlier discussion with law professor Bruce Pardy, we looked at those rights and what they mean, and what we determined is they don't mean much. And with recent rulings involving the Cowichan and Musqueam Nations, landowners are more concerned than ever. Here to discuss what might be ahead on the road ahead is Brian Giesbrecht. He's a retired Manitoba Provincial Court judge, appointed in 1976, who later served as an associate chief judge, as well as the acting chief judge until he retired in 2007. He's written many articles on this subject, and we're glad to have him. Brian, welcome to Bridge City News.
Thanks, nice to be here.
So first of all, I would love to hear your thoughts on the Cowichan decision in BC and the concerns that are being raised by landowners in Richmond.
Well, it is a very disturbing decision because it deals with private ownership, fee simple ownership, but it wasn't that surprising because I mean, I've been following, as many have, the Supreme Court cases post 1982, and this was almost a natural development because the Delgamuc case, for instance, and the Silcotin case were just as radical in that they said that Aboriginal title would apply in large parts of the province. The difference between those cases and Cowichan is just one of degree. They involve public land, and very often in places that are quite remote, and so they didn't directly affect homeowners. The Cowichan decision, on the other hand, directly affects homeowners, and it's caught everybody's attention, as it should have.
Right. And now, more recently, though, now we've seen Ottawa signing this rights recognition agreement with the Musqueam Indian Band. What leaps out at you from that deal, or what you've heard of that deal and that large area of Vancouver that's involved?
Well, I think this is just a sign of things to come, and it's not going to be confined to British Columbia. People feel that this is something that's peculiar to BC, and BC is peculiar in a number of ways, but eventually these modern treaties, that's what they're being called, are going to spread right across the country, because there is just absolutely no way that the treaty chiefs, the chiefs that have been under the numbered treaty, are going to be content with what they have, with the very modest treaties they have, when these very, very rich BC agreements get signed. So I think people are in store for much more of this over the next number of years.
And I think it is worth diving into a little bit. Let's talk a little bit about historic treaties, which, of course, I think people in Alberta and Saskatchewan would be aware of, you know, Treaty 7, Treaty 8, and some of the treaties that are historic. But BC, when you say modern treaties, these are different?
They're very different. The original treaties, the idea was that the Indians would give up whatever interest they had in the land, and in turn there was some fairly modest compensation. For instance, they received $5 per year. They received some farm implements to help them get busy farming. They received the right to hunt and fish on unoccupied Crown lands, and then some other minor consideration. Of course, they received reserves where they lived. But they gave up their land. They ceded any interest they had in the land. That's not what these modern treaties do at all. This Musqueam agreement, for instance, that you referred to, the Musqueam people don't give up anything. They don't surrender their Aboriginal title at all. As a matter of fact, there are terms within these agreements where these things will be renegotiated in a number of years, and any additional court decisions that favor them would be factored into these new agreements. So the modern treaties are very different, and they're far, far richer than the original treaties.
But we do need to talk, I think, about how, I think, common law, most of the common law in this country has been based on individual rights. And I think Bruce Pardy enlightened us about what we're now calling, I guess, group rights. Is that what's coming into play here?
That's exactly what's coming into play. And in 1982, which is a pivotal year in our Canadian history, of course, because that's when Section 35, which has existing
Yeah.
Aboriginal rights, and there's a long story behind that, which I can tell you if you
Well,
like.
we covered that with Bruce Party, so go
Okay,
ahead.
that's good. He's very good at that.
Yeah.
I respect him very much. But subsequent to that, from 1982 on, the Supreme Court went on to, and I don't want to be disrespectful here, but I'm saying they literally invented a whole host of brand new so-called Aboriginal rights, tribal rights. You can call them collective rights, or you can call them tribal rights. So now we are in this position where you have a Haida land and a Musqueam land and that sort of thing. And that was never supposed to be. And I would also say that if the premiers in 1982 could see what was happening in BC right now, that would have been uh, that would have been considered a betrayal, because they were very clear that the Aboriginal rights, the existing Aboriginal rights that they were agreeing to put in Section 35, um, were as of 1982. No new rights were to be invented, and they would only agree to sign once that word existing was put in. But then no sooner had that ink dried, then the Supreme Court began to expand incredibly the list of Aboriginal rights. So the ultimate result is the Cowichan case. But there have been also many other cases that were almost as radical. But as I say, people didn't really pay attention to it because it was out in the bush someplace and they didn't think it applied to them. But now I think they're coming to understand that yes, it does.
So now that we are seeing these cases, the cases that do involve urban areas, and Canadians' belief, I guess, that that's their property, how do you see this playing out in the courts and outside the courts?
Well, I don't know that there's an easy answer. My own belief is that at some point Canada is going to have to um, have constitutional discussions to iron all of these things out, because the direction we're headed right now is an absolutely hopeless place. British Columbia is now trying to sort of co-govern with 200 plus different First Nations, as they're called, and that's a hopeless formula. It cannot happen. And as I said, the original intention of this country was to have a nation of citizens with equal rights, and somehow we have veered off into this very weird space where we are dividing up into tribes and that sort of thing. And I think that constitutional discussions are probably inevitable. That's the only way to get out of this mess. I don't see the Supreme Court doing very much except distinguishing certain cases. I don't think the Cowichan case will stand. For instance, it's wrongly decided, and even the historical observations that the judge makes there, it's very easy to spot many errors in that particular decision. But I don't know that we can have a great uh, deal of help from the Supreme Court. I'm not sure how much the provincial government is going to be able to do. In British Columbia, for instance, they want to abolish DRIPA, which absolutely they have to do. But they also have to abolish all of the other um, um, baggage that's come with it. I don't know that you've discussed practice directives with Bruce Party, but that is those. Do you know what I mean when I'm talking about practice? They are the reconciliation practice directives at both the provincial and the federal level. And basically, they say that government lawyers are not able to raise their best arguments. So in the Cowichan case, for instance, they didn't even argue extinguishment, which is the probably, well, I would say the correct law that once a province started issuing land titles, any previous rights were extinguished. Maybe there's a case for compensation or something like that. But this whole notion of putting an Aboriginal senior title on a junior fee simple is just really literally quite insane. So I think they have to get rid of these practice directives, which have been around now for a number of years. They have to let the lawyers, the government lawyers at the provincial and the federal and municipal level, argue cases, argue their best cases, and not simply be bound by these special rules that they can't be offensive to reconciliation, etc. And those are partial answers at best.
Brian, I appreciate you joining us to discuss this. Thank you so much for your time today.
Okay, pleasure.
Brian Giesbrecht is a retired Manitoba judge and senior fellow with the Frontier Centre for Public Policy. And that wraps up our special Bridge City News special report on Indigenous land rights. No doubt we will see more heated discussion around this issue as we see a shift toward heightened sovereignty with increasing legal recognition of Indigenous title and authorities disrupting what had been traditional property law, particularly in British Columbia. We thank you for joining us. I'm Rod Kurtz.